Hey, Koumjian, welcome. Thanks for being here. You've worked at an impressive array of international courts, internationalized courts, some that were slightly more domestically located in Bosnia, hybrid courts. Is there any particular model, or did any one of those tribunals in particular work better than the others? What do you see as the kind of lessons learned from your career across these tribunals and tribunal types?
Well, I would say that each type of tribunal has its advantages and disadvantages, and which is the right model would depend on the situation in the particular location, country. There's issues about cooperation of states, about the ability to protect witnesses. One of the advantages of hybrid models that are in the country, such as the extraordinary chambers in the Courts of Cambodia, is that it's in the place where the victims suffered, and it's accessible to the victims. So the court in Cambodia, well over hundreds of thousands of individuals, literally hundreds of thousands, I think the figure now is close to 500,000, have visited the court and seen part of the proceedings that took place. But there's other advantages of, for example, a ad hoc tribunal mandated by the Security Council, such as the ICTY and ICTR, because this gave the court the legal authority to issue orders to states. States had a legal obligation to comply with the orders of the court. And certainly any court cannot function if it doesn't have the power to enforce its orders. Domestic courts, you have the police. And generally, in any country that works, judges make orders, police carry them out. These international courts, none of them have a police force. They don't have armies. They depend upon the cooperation of states. So the legal authority and the exact political situation involved, the willingness of the domestic government involved to cooperate, plays a big role in how successful the courts can be.
Do you see any particular kind of trajectory in international criminal justice towards one type of model over another?
I see a trend towards domestic prosecutions, away from internationalized tribunals. I'm afraid that the main motivation for that is cost, rather than really the effectiveness of the tribunal.
You've touched upon the point that it's often seen to be best to deliver justice as close as possible to the victims and survivors, and that domestic justice for international crimes is, on some level, ideal. But what are some of the obstacles and opportunities that exist when you pursue that kind of accountability on the domestic level where those types of crimes actually occurred?
Yes, when I say, close to the victims, I particularly mean it's good for them to have access to it. If they can go and visit the court. Of course, most people are not going to go every day to a trial that takes years and years. But if it's present in the court, in the country, I think they're more likely to be aware of it. The local press is going to cover it a little bit more closely, which is not to say that it's impossible for something like the ICTY to bring their proceedings closer by having good outreach programs, by making the proceedings accessible on the internet and local television programs, etc. But I don't want to say that victims always want a domestic process. What I found is in conflicts from Bosnia to the conflicts in Sierra Leone or Darfur or Cambodia, all of these conflicts, victims have a very fundamental need and desire to see a court recognize what happened to them, the severity of it, that this was wrong, and to say that individuals were responsible. It wasn't just an action that happened on its own. People did wrong. And I think they particularly find satisfaction when that is done by an internationalized court. One of the victims, I believe her name was Ms. Chan Ho, one of the civil parties in the Cambodian court. I recall at the end of her testimony, she gave a statement, and she talked about how she had lost 20 members of her family during the Khmer Rouge regime. But she thanked the court and the judges for coming across the oceans to bring justice to her family, to the souls of the departed.
So you've spoken about the kind of linkages that you see in some of these situations between transnational organized crimes and international crimes. Do you see these linkages on a regular basis in your work? And if so, do you see a way to more effectively link them in terms of their investigation and prosecution?
Well, I think definitely in many conflicts, the sad truth is that the conflicts are often being fueled by people who are financially profiting from what occurred. And they're financially profiting because of things like being able to extract diamonds or other types of minerals without having a monopoly over those because of the conflict, without having to pay the proper taxes, etc. Others profiting from the sale of weapons to various parties involved in the conflict. So I think it's important to try to attack those at the roots. Some of these, of course, are people that are outside the borders of the country. These are often civil conflicts, but people that are profiting from abroad. And I think efforts have to be made. Things like the Kimberley process, which was set up to try to reduce the role of diamonds in conflicts. I think it has had some successes. It certainly, like any type of effort like that, you have to constantly fight to plug the leaks. But I think those efforts are being made. So I do think there's a linkage, and there's a need to go after those who are profiting from war, profiting from these horrific suffering of victims of these conflicts.
Thank you very much for your time.
It was a pleasure.